Good afternoon. My name is Matthew Dietz. I am Litigation Director from Disability Independence Group. We are a disability rights advocacy center from Miami, Florida, and we work statewide. And today I'm going to be talking about the rights of parents and children with disabilities to receive accommodations to receive permanency. A lot of the work that we do at Disability Independence Group is both litigation and advocacy. In court and out of court. And today what I'm going to talk about is real life experiences and how to get accommodations for children or parents in the dependency system in order to have equal access to the programs and services. We're going to start with a video. And this is something that I've been seeing more and more often, parents with intellectual or developmental disabilities who choose to have a family. And the question is, how is it determined that they can be good parents or can't be good parents, and what additional services or protections are needed for these folks so they can be parents?
Okay. What's you looking in?
Amy and Eric love their two children more than anything, but they've lost custody of Christopher and Hunter. Not because they were neglectful or violent, but because they say their IQs are too low.
I don't think that IQ has anything to do with raising your kids. The only thing that should matter when it comes to raising your kids is that you love them, you're able to support them, and you're just there for them and their needs. And I can do that.
Child Protective Services in their town of Redmond, Oregon, first came knocking in response to an anonymous call. It was alleged that the couple was not capable of caring for their son Christopher when he was a newborn. Authorities took Christopher when he was just days old and placed him in the custody of a foster family. Both Amy and Eric have high school diplomas, but as part of the state's investigation, they were given IQ tests, they said. She scored 72 and he earned 66. An average IQ ranges from 90 to 110. They said this was used to justify keeping Christopher in foster care. The Department of Children's Services says that being developmentally disabled is not the sole basis for removing a child from his or her parents. Amy and Eric were allowed to visit with Christopher, but haven't been able to live as a family with their son. When their second child, Hunter, was born in 2017, they were shocked to have him taken away too. It was traumatic for Amy and Eric.
I was very upset, and I wanted to be able to bond with him and have that attachment with him, and 2 days is not very long to be able to bond with your newborn son.
Shireen Hagenbach is an advocate working with Amy and Derek to help them regain custody of their children. She says,
the court-appointed attorneys are too busy to look into these cases. They didn't even know that they had normal high school diplomas until I came in the picture. So they haven't even had proper representation. I think if they had that from the beginning, they would have had Christopher back in the first 6 months.
But this family doesn't have much time.
We are still fighting in the courts here. CPS technically, legally doesn't even have jurisdiction over Hunter yet. And we have a court date set for Christopher for terminating our rights in December.
Meanwhile, the couple lives in limbo, waiting for a court to decide whether their children get to come home.
It frustrated me a little bit because, like I said in the beginning, IQ shouldn't matter. I mean, I shouldn't be judged on what my IQ level is. It's just a number. It's not how I parent.
This is Inside Edition in depth.
This is Kate.
Hey.
She takes 2 prescriptions. Kate's son Jack takes 1.
Prescriptions. Here we go. So the issue of persons with disabilities having children is a huge issue now, and it's a huge debate that that's taking place across the country as to who can be a parent and what supports they need to be a parent. But if you look at persons with disabilities solely because of their disabilities, parents with disabilities have higher rates of having their children removed. State statutes sometimes specifically include disability as grounds for termination of parental rights, and there are perceived limits on the application of the ADA, which they're not, and we're going to go over them, especially at the termination and even at the shelter phase. There is bias and speculation as to what an unfit parent is and whether or not parents with developmental or intellectual or other disabilities can actually parent. And there is inadequate training across the board in relevant accommodations that parents or children with disabilities need within the system itself. So, and there's an issue. And this is the findings of the National Council on Disability. And the National Council on Disability is a federal agency that provides guidance to the executive branch on disability policy. And their findings were people with disabilities who are involved in dependency or family proceedings regularly face evidence regarding their parental fitness that is developed using inappropriate and unadapted parenting assessments and a national dearth of resources to provide adaptive services and adaptive parenting equipment to teach adapted parenting techniques. Even when such resources exist, dependency and family courts don't often use them. So there is not a test, there is not a device, and most courts that you see, and it doesn't matter where in the state of Florida, have no idea what's out there for parents with disabilities or for parents to care for children with disabilities. So in one study, it found out that removal rates with parents that have a psychiatric disability were as high as 70 to 80%. For intellectual disability, from 40 to 80%. In families where the parental disability is physical, 13% have reported pathologically discriminatory treatment in discovery cases. And we'll talk about a couple of my cases in which a parent that had spinal ataxia was thought that she was going to be unfit because she couldn't walk across the hospital room to care for her newborn child. So what is the ADA and how can it be used to advocate? When we're talking about the dependency system, we're talking about Title II of the ADA. Title II of the ADA applies to local and state governmental facilities or programs or services. It provides that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or denied the benefits of the services, programs, or activities by such a public entity or be subjected to discrimination by any such entity. It's really broad, isn't it? That's the law. The rest is a regulation. So basically what it means is that a person with a disability is entitled to equal access, equal protection, equal opportunity to enjoy the benefits of a program or service. Now, when you say a program and service, you're not talking about just walking in the courtroom itself. You're talking about the entire service. So when you're talking about Chapter 39, you're talking about the entire dependency program. Every program and service that the court orders is subject to the ADA. So any accommodation in any of those services is subject to modifications or other items that we'll talk about. Now, what is the ADA and who is defined as a person under the ADA? The ADA has three prongs to define a disability. The first prong is an actual disability. A person who has a substantial impairment to an everyday life activity. The second is a record of or a history of having a disability. For example, if a person has a learning disability and has an IEP, they are regarded as having a disability. Whether or not you can demonstrate a substantial limitation, they have a history of having a disability. The third type is a regarded as. Regarded as happens a lot and more often in dependency proceedings where you assume, you use stereotypes to believe that a person actually has a bigger impairment that a person may have, if any at all. For example, how a person may speak may have nothing to do with regards to the parental ability or their intelligence, and they may not have a disability, but it would be a perception of or a stereotype of having a disability. So this is a big one. What's included under Title II? Anything that you could imagine with regards to a person with a disability and a program and service of a local or state entity. Providing parents with disabilities an equal opportunity to participate in programs, services, and activities. Administering service programs and activities in the most integrated setting. You can't have stairs going into a courtroom that you expect a parent in a wheelchair to use. And also the programs and services that's attached to the dependency settings have to be in an accessible location. Eligibility criteria. You can't do something because of your disability. You're not eligible to be a foster parent because you're blind or you're deaf. That is eligibility criteria that has nothing to do with one's ability to be a foster parent, to be a parent at all. Furnish auxiliary aids and services when necessary to ensure effective communication. This includes sign language interpreters, items in Braille, items in an accessible format. Provided as needed benefits, services, or advantages beyond those that are required by the regulation to people with disabilities. If a longer reunification plan is needed, you could modify rules, policies, and procedures. If somebody says that these are the rules, this is what's in the regulation, this is what we have to follow, you could say, as an accommodation for a person with a disability, we need a modification of those rules. Non-imposed surcharge on people with disabilities. This happens a lot when you're involved with a person who's deaf. You got to pay for your own sign language interpreter if you want to be a part of this program. You have to bring your own interpreter with you. Not deny the benefits of programs, activities, and services to people with disabilities because the entity's facilities were not accessible. We're going to have the Alcoholics Anonymous meeting on the second floor of this facility. You're bedbound and you're not going to be able to attend this. So I'm sorry you can't go. So the issue with dealing with persons with disabilities, and we could talk more about this during question and answers, about what type of accommodations are necessary for persons with a disability to have equal use and enjoyment and equal access to the programs and benefits of any program the state has. And I get calls about this all the time. The parenting class is in English. I can't go to the parenting class. Well, that's not a disability thing, that's a language thing, but it's still an access issue. But parenting class is in English and I'm deaf and I need a sign language interpreter, they're not going to provide one. I can't go to it. These are things within the auspices of the court that the court's obligated to provide or to require that the entity provide accommodations. Now, I love this picture because it shows what an accommodation does. Everybody's entitled to the apple, but some people just need a little bit different access to have equal opportunity to get the apple. It doesn't provide you equality per se, it provides you an equal opportunity. So the ramp provides equal opportunity for a person in a wheelchair, a step, in a cane. So everybody's different, but everybody's entitled to an equal opportunity. Now, I'm always told no, and I'm really bad at accepting no, because they say no. Why no? Because our regulations say so. Because we don't have the funding. How often do people say we don't have the funding to do that? All the time? I mean, I actually am doing a summary judgment right now involving deinstitutionalization of getting people out of Carlton Palms, and the issue is, and they're all out, but they need adequate services, and they're saying, we don't have the funding to do additional programs and services. We don't have the funding to keep you out of an institution. We don't have the funding to provide you these items so the family remains unified. The standard and if it's an ADA issue, the standard is undue financial or administrative burden. It is a high burden. It's not a low burden. And this is what the regulations say, and I always like the regulations, and I think you guys get copies of the PowerPoints as well. The decision that compliance would result in such alteration and burden must be made by the head of the public entity or his or her designee, not the caseworker. The head or their designee, considering all resources available. It's not a cost-burden relationship. It's what does the entity have? How big is the entity there? What do they have in their own resources for use in the funding and operation of the service, program, or activity, and must be accompanied by a written statement for the reasons for reaching that conclusion. If anybody says no, I'm always like, put it in writing. Why? If an action would result in such an alteration or such burdens, a public entity shall take any other action that would not result in such an alteration or such burdens would nevertheless ensure that individuals with a disability receive the benefits or service provided by the public entity. An example. Person has, yes? Oh, I'm sorry. Okay, an example of that is a person has multiple chemical sensitivity disorder, can't go in the courthouse. You go to the courthouse and you say, listen, I need you to send in an entire housekeeping crew to scrub it to make sure that it's totally fragrance-free. That would be a fundamental alteration, wouldn't that? How are they going to do that? But an alternate of that is you need to participate by phone. That works. Some judges have things that they don't want you to participate by phone. Can't go in because of a disability. Unless there is some reason that it would be a fundamental alteration. For example, this is during a trial and you need to cross-examine and you have a jury there and a jury has to check the temperament of the witness being cross-examination in a criminal trial. Yes, then you're going to have an issue of not appearing by telephone. But it doesn't often happen in a status conference during a dependency hearing. If there is a disability-related reason that a person can't show up, absolutely. Phone, FaceTime, video. There's many different ways to do it. None of it would cause a fundamental burden or a fundamental alteration, but making sure that your facility is fragrance-free may be kind of tough, especially in a place like Miami. Not that people use a lot of perfume in Miami, but I'm just saying there's a lot of people. Not that it wouldn't hurt, but okay. Persons with disabilities have the right to bear and raise their children. It's a remarkable thing. Children cannot be removed from the parent solely based upon their disability of the parent or a child. And I've had cases involving parents with disabilities and children with disabilities, and parents who are told that they don't have the ability because of medical neglect, they can't care for their children. And they're not provided with the services and they're not provided with the resources in order to get additional service so they could remain unified, have the family remain unified. States are required to provide supports to these parents to care for their children with disabilities. Children with disabilities have the same rights to benefits, privileges, and services and programs as any other child would have, and should be provided the resources necessary to live and grow both physically and psychologically in a community-based setting. A couple of years ago, well, 2011 to 2013, the state of Florida used to take medically fragile children and used to put them in nursing homes because they refused to give parents adequate home-based care. So it was an issue. And there were many foster children, not even children with parents, but foster children that were medically fragile foster children that were put in these settings. And they were put in these settings because there was an insufficient amount of medical foster homes in order to place these children, and there was no effort made at the time to have additional medical foster homes. These children have the same right to have a community-based setting as children without disabilities. And that was a huge issue that now we don't have that same issue because parents and foster children should be provided, and if they're not, please tell me, they should be provided adequate home health in order either to get the services at home or services in a foster home, even if it's not a medical foster home. How do you get equal opportunity? You really have to look at the whole plethora of different services that the state offers. And when you have a child with a disability or a parent with a disability, what services are out there that need modification? I mean, if you look at family law, parenting classes, counseling, visitation, what part, in looking at the person's disability, what things need to be modified for that person's disability? And when you're talking about disability access and the history of disabilities, think about that our world, our structures have been constructed, whether it's physical or policy-wise, for able-bodied, neurotypical persons. So it's not structured for the family that we saw in the beginning to say, what services do you need in order to be a family? How can we structure your life? What are your supports that you have as a family? What parents, grandparents, neighbors do you have? What are your natural supports? Not how you individually can care for your child. And there is a whole difference in looking at it not only through the eyes of somebody who is neurotypical and able-bodied, but somebody who is neurodiverse, somebody who has an intellectual or developmental disability, or who has a physical disability, or sensory disability. A couple of years ago, there was a huge issue about parents who were visually impaired who had their children taken away because of the assumption that they could not take care of their children because they were blind. So other things like medical care. What additional medical care does that child need in order to stay unified or to stay in care? Is there additional therapies a child needs? Is there additional respite service? Is there additional nursing to maintain unification? At least between the time of the shelter proceeding and the TPR. And court proceedings. And this is, I mean, when people think about the ADA, they focus on the court proceedings, what is accessible, what is not accessible in the court proceedings, and that's the easy stuff. I mean, mediation, accessible documents, effective communication, interpreters in courts. Those are the ones that people always think of off the top of their mind, not the programs and services that underlie the program. But you have to remember, when we're talking about Title II, we're not talking about whether or not we should have this room laid out in an accessible fashion where there are not chairs in front of every desk here, and there's not space here for a wheelchair. I mean, even if we speak about the whole program in its entirety, but if you're talking about more in the design of how we think as a person who is disabled, we would go into a room like this and say that this is fine. A person in a wheelchair would come in and say, there's no place for me to sit. Because if you look around, not one seat. The tables are all positioned in a way that even if you took away a seat, a person in a wheelchair couldn't get through. Is that fair? Is that equitable? It's not. But it's how people structure society. And that's how our system is structured. Types of accommodations. Now, the types of accommodations, and then we'll get into my own thing that I consider war stories, which people like a lot more when you actually talk about scenarios when this stuff happens. But types of accommodations, you guys have a lot more experience in dealing with the system, and you know what your kids or family wants or needs. And what they need and their accommodations, the only limits is to what the person's needs are. So things like additional mental health, behavioral health would be an accommodation. Extensions of case plans beyond 12 months. Sign language services for investigations. Assistance with transportation needs. Additional in-home or out-of-home respite service for parents. Additional life skills or education classes for independent living and employment. Additional in-home or out-of-home health care services. Specialized living options for foster youth aging out of the system. These are all accommodations. These are all accommodations that have a cost. So that's why it's difficult to get them. But it's an accommodation. All accommodation, most accommodations under the ADA have a cost. Some don't. Moving the table 2 feet, taking out the chairs, has no cost, should be done. But some accommodations do, and some accommodations are expensive, like sign language interpreters. It's required. That's how you provide equal services. That's how everybody gets a hold of that apple. Determining what accommodations are appropriate. This little girl is Marie Ferre. She was 14 years old when she died. Her mom was an older lady who had 4 herniated discs. Marie Ferre had cerebral palsy and an intellectual disability. Her mom cared for her for 14 years, and she was only given 8 hours a day home health and no home health overnight. She didn't go to a doctor's appointment, so she was sheltered by the CPIs in Hillsborough County. And then she was brought into an immediate shelter. She was sheltered, she was brought to a hospital. She was brought to Tampa General. So they went to the shelter proceeding, and the judge said, in the shelter order, the child shall be returned to the mother. Services are in home from midnight to 7 a.m. And it was a normal form shelter order, which I'm sure most of you have seen, that basically say if you have any additional medical services beyond what's emergency or immediately necessary, you have to get court approval. The state and the CPIs determined that this was an aspirational statement. So they called up the person from that assisted them with their Medicaid issues at ACA, and they said, no, you can't get 24-hour home health. Don't even bother. It's going to get denied. After she said, don't even bother, it's going to get denied, then they started efforts to find a nursing home to transfer Marie to. The mother went ballistic, filed an emergency motion, which wasn't heard, because they rushed to transfer the child to a nursing home. And the child was transferred to a nursing home from Tampa to Miami and died upon reaching the nursing home. The case currently is about 3 years old. We resolved it already with the state, and we resolved it with the CBC, and we still have a case against the CPIs because they're saying that they're immune pursuant to the 11th Amendment to the Americans with Disabilities Act because they're an arm of the state, and therefore they have 11th Amendment immunity for their actions. The case is currently pending before we won in the 11th Circuit Court of Appeals, and Hillsborough County CPIs has just filed a petition for certiorari for it to be heard in front of the Supreme Court because they believe that they don't have the responsibility to provide they don't believe that they're liable under the ADA. So I have a response to a petition for certiorari due in 2 weeks about this case. But if you think about the accommodation which would have allowed Marie to stay at home, the accommodation was a simple accommodation. It was having a person help her 8 hours a day for $8.25 an hour. And that's what the judge ordered. And they disregarded the order. Now, I have to tell you, it's difficult to do ADA cases in any event in the Middle District of Florida because if you haven't heard, there have been a ton of lawsuits involving curb cuts and bathrooms and internet sites. So when you have a case like this, you really have to convince a judge that this is really a thing. So I'm the judge who was more concerned with the issue that the CPIs and the state neglected a shelter order, and my concern in this was the fact that this is an accommodation request. The mother said, I need these additional services to keep Marie in my home. The judge said, yes, you did. Let me write it down in the order. This is the accommodation you need. But it wasn't in those words, in the ADA words, but you have to remember, under the ADA, there are no magic words. I'm a person with a disability, I need this assistance. And that's what this is. They neglected the accommodation request. And it's important to have the judge there, but this accommodation request would have kept Marie in her home until she had a trial with the TPR. And then in the meanwhile, what would have happened? She could have applied, the judge could have written a letter saying, you're going to lose your child if you don't get 8 hours, and sent that to a fair hearing in Medicaid, and the fair hearing officer would have said, sounds like reasonable and medical necessary to me. We're going to order it, and the case would have been over. So the fact is that having a judge write an accommodation request on the shelter order is a huge thing, because not only could she have gotten the services to keep her child home, she would have also they would have also probably approved the services from Medicaid. Yes?
Can I ask you about your phrase, accommodation request?
Yes.
I don't personally read that as a request. When it's a court order, the judge is saying services are at home from the 97. I don't know if he's saying they need to be, or if he's acknowledging they already are. Like, I don't know if that was their reasonable efforts or what went behind it, but your phrasing accommodation request makes me think it's more like a request, where it doesn't come across that way from that, my reading of that.
Okay. Great question, because I'm usually buried in my nomenclature of the ADA all the time. And this to me is an order. It's not a request, and it's mandatory. But in the nomenclature of the ADA, in order to get, two types of discrimination. There's discrimination on its face. You cannot do this because of your disability. And then there is your right to a reasonable accommodation. To get a reasonable accommodation under the ADA, there has to be a request made for reasonable accommodation, and that is just the way to get what you need. So it doesn't matter whether or not it's entitled a request or it's entitled an order. And if you don't make a request, then the state or any defendant is not aware of the fact that the person needs an accommodation or what the accommodation is. But it's just opening the door. Yes?
That's perfect, was my question. So if the person doesn't know to make the request, and then a year later they're facing termination because the state is saying they're disabled, they can't do it, does that not give them the obligation? Don't they have knowledge? What happens to them when the parent doesn't make the request and then they use that disability against them?
Then they lose. It's awful. Unless it is slap you in the face clear. There is no obligation for the state to do something. So it has to be slap you in the face clear. That's the best way that I could say it in my review of case law for the past 20 years. If a person is in a wheelchair and you say you have to get up that step in order to do that, and we're not going to give you a ramp, that's clear. Person who's blind with a guide dog, and you say, we're not, there's nothing that we can do, that's slap you in the face clear. But in anything that is not blatantly obvious to somebody who has less than normal knowledge, you're not going to get it. And it's the same way whether or not it's benefits and public services or employment. So if you're an employee and you need an accommodation in your job, you always have to request the accommodation unless it's slap you in the face clear. So, and I actually even had a case in which I had a deaf child at Orlando Regional, and they didn't give the child an interpreter, a sign language interpreter, when the child had a cholecystectomy. And the judge said, no, there was never a request made for an interpreter, even though the child was deaf, because the child could have communicated in many different ways. The hospital had no idea that the child needed a sign language interpreter. And that went up to the 11th Circuit, and I lost it on that exact issue. So it's one of these things that you say to yourself, really? That could happen? But yeah, even if keep it simple, stupid, you just always have to put them on notice that a request is made. Also, on top of that, a request doesn't have to be under the AD, under section 12131 of the ADA. We're making a formal request for accommodation that my client needs X, Y, and Z. It helps to do it that way, but it's not necessary. They have to know that a request is being made because of a disability. However, if you don't know how it works, you're going to be told no, because the person who you're asking isn't going to know how it works. And then what you do in order to make sure you're asking is you go higher and higher on the ladder to be able to ask. Now, parental stereotypes. This is a case that we're about to bring involving Alicia Cesare. Alicia is a woman that has spinal ataxia, uses a walker, also has a developmental disability. Her boyfriend is autistic. She lives with her mom. Her mom is the woman in the green. Alicia, little tiny woman, gave birth with no anesthesia, had a baby at the hospital, and the hospital room was so tiny she couldn't stand up, and because she couldn't get her walker around to get to the baby. The social worker called in the CPIs in Broward County, and they started shelter proceedings. And the investigation, if you look at the language, the investigation revealed that on 2/1/2018, the mother gave birth to Elijah at Memorial Regional Hospital. Medical staff described the birth as incidental, as the mother and father both display developmental delays. How could a birth be incidental? I don't know. Do they not know what they're doing? Do things slip? This was in the investigator's report. The mother cannot walk on her own and needs assistance with performing activities of daily living. The maternal grandmother who provides most of the care for the mother does not leave the mother home alone, as she cannot care for herself. So she has a network of care. And it really does, and none of it talks about any developmental disability or the extent of developmental disability for the mother. And then the mother could communicate. The mother has a fervent desire to be a parent and does not fully understand how her disability places the child at risk. The mother's movements are involuntary, and she could seriously injure the child who is vulnerable and needs protection. The CPIs have no guidance for what to do with parents with disabilities or children with disabilities. That's why we're bringing our case. There has to be guidance. To have the assumption that a parent with a disability cannot care for a child just by looking at her, even though she has familial supports, is not only in violation of Chapter 39, it's unconstitutional, because there's a constitutional right to bring up your child. Unless for some reason there's going to be some harm to that child, and there is none. And the additional discrimination against the parent is when you imply that a birth of a child is incidental. I just don't know how that could happen. So this time I was brought in during the shelter proceeding, which was more fun, because those judges never see, folks like me there, which makes it fun. So the judge got it. The judge said a safety plan and services to be put in place for protection of the child, family to assist in caring for the child. This is a material condition of placement under the ADA, services to address functional effects of disability when and if identified, to allow parents to work towards independent living if desired. Judge got it. Then afterwards I did a 10-page motion to dismiss, and the judge dismissed the case. Now we're going to file a 1983 case for violation of civil rights, because this mom is always going to be in danger of losing her child at any time. They're going to look at this mom and say, you're unable to do it. There is nothing in the regulations protecting this mom. So she's always going to be at risk. And this mom, what needs to happen in looking at this is you need to look at the protections of the family. What additional programs and services are out there for the mom in order for her to be able to take care of her child? What additional things does the mom do? What about the father of the child? What about his family? You're talking here about a village raising a child. Is that okay? Absolutely. Absolutely. And there's nothing that, because this mom doesn't have an IQ of 110, that would prohibit her from being a parent. That this mom cannot get services or products. If she cannot hold the baby herself, there are products that you can get. There's auxiliary aids and services that are available that Medicaid would pay for. The problem is, and you get this more because not only is this mom not only is this mom, does this mom have a disability, the family's primary language is Creole. That is another issue that makes it even harder for the access of services. And those are accommodations, and because she had a good advocate that identified this in the shelter proceeding, it would not have happened. She would have lost her child. What accommodations to request for your client with a disability? I like putting pictures of myself with my clients. This one I love. This is Anthony and his service dog Stevie. That wasn't allowed to have Stevie, who was a seizure alert dog, in Broward schools because they said that that Stevie's grandma, Anthony's mom, would have to come to take care of the dog in school. And Judge Bloom said, no, it's a reasonable accommodation. I'm sure that you could find a one-on-one aide that would much rather take care of a dog than a child. And also, Stevie wasn't easy. Stevie would have seizures, and the one-on-one aide had to be trained to insert a suppository. Anthony, no, you don't want to insert a suppository in Stevie. That wouldn't be good. Stevie's the dog. Anthony's the child. So you wouldn't want to do, you wouldn't want to insert Dietz into Stevie. No. So Judge Beth Bloom said, no, nuh-uh. It's not unreasonable for the school system to have a dog, and what would they have? And the easy thing is, and it's a disability thing, and distinguishing between the disabilities, if instead of having a seizure disorder, a nonverbal, if Stevie was a guide dog, and he was a little 6-year-old blind boy, of course they'd be allowed the guide dog, but not the seizure alert dog. Well, this is an accommodation. And accommodations come in all shapes and sizes for all different types of disabilities, whether or not they're emotional support animals for kids in the foster system who need their dog to go from premises to premises with the person, which basically folks don't even think about, but I wrote an article about it in the Florida Bar Journal about 2 years ago, how emotional foster children are allowed to have emotional support animals. But determining what accommodation to request. Always speak to your client. Always speak to the child. Find out what they want, what they need, what works with them. Never assume. If they're able to communicate what they need and what they want, ask them. If the parents have an issue and you're reviewing the parent and speaking to the parents, ask what the parents. Don't rely on other folks to say what they need, unless for some reason they're nonverbal and can't express what they need or what they want. A person usually knows what they're used to. Happens all the time when they say, "Okay, you can't use this accommodation. We'll give you this." A great case that came out of that was a blind person that wanted to use her screen reader on her computer rather than having an in-person reader read something to her on a test. And the court said, no, the blind person's been using the screen reader for the past 10 years. She will not be able to perform the same way if she had an in-person reader. So people with disabilities know what they need and know what they want. In the event that they don't, then there's additional things that could help. For example, for products and services that they may not know, like Alicia. Another important reason of that is it empowers the person by speaking to them and asking them what they want. A major thing is ensuring the dignity of all by taking away the power of knowing of asking a person what they need, what they would like. You're taking away power from them, which is especially important for a person with a disability. And speak to them about what's to be expected in the future. What do you need? What are the other things that a person will be doing? Like, for example, as a lawyer for persons with disabilities, I know that they're going to need interpreters in court. I know in the beginning of the case to ensure that they get the interpreters in court or interpreters at depositions, or making sure that things are in accessible locations, or finding out who they need or who they have conflicts with, and asking the questions in the inception. Sometimes there may be several accommodations that are available that will address a disability-related need. And if your client's unfamiliar with it, it may not even work, such as the screen reader versus the in-person reader. Persons with disabilities are unique, and they know more about their needs. They know more about their disability. They know more about their history of accommodations, their level of dependence, and many other factors. There's a lot of folks that are going to assume what they need and what they want, it's really important to know what that person needs. And also, a person, depending upon the person or the family with a disability, they think accommodations are a matter of charity and not a matter that is required. So they're going to be like, okay, this is good enough. It's not good enough unless it gives the person an equal opportunity to benefit from the program or service. So it's important to not only to review the physical barriers that are out there, review the policies and procedures. Most barriers that you'll see in the dependency system are policies and procedures that are barriers. For example, when we were talking about Marie Ferre with a person from ACA saying, I'm sorry, we don't provide 24-hour care and services. It's just don't even apply. That's a barrier. That's a policy and procedure barrier. That's a person putting up a barrier that prohibits reunification. That the way to get around that barrier is to say, that's not, show me the rule. Show me the case. Show me something that says you actually have this barrier. I have this where I don't see a rule or a policy and procedure. I usually think people are making things up, and I ask more questions. If there is a policy and procedure under the ADA, you could ask for a modification of the policy and procedure as long as it's not a fundamental alteration or an undue burden.
May I ask a question?
Yes, absolutely.
On your policy and procedures, am I looking at the administrative code, or am I looking at the accommodation for disabled? Which one am I looking at?
You're looking at the administrative code.
That's where I was.
Yeah, you're looking at the administrative code. You're looking at the official rule. The accommodation rule is flexible, and it always depends upon the proceeding in which you're in. That's why it's called a reasonable accommodation. It's these wonderful gray legal rules that basically are very malleable. And that's why if it's reasonable, it's allowed as long as it's not a fundamental alteration or an undue burden. So a lot of times a state entity will say it would be an administrative burden. And if it's a great administrative burden, like you're creating a new program for a particular person, that's the definition of an administrative burden. But if it's an additional service, an extension of a service, even if it's an administrative rule service, it's something that they have to do as long as there's a nexus between the disability and that need. If there's no nexus between the disability and the need, you're not entitled to it because it's not an ADA accommodation. But as long as there is, and you could think of anything that would fit within that context. Sure. Determine the barriers to program and services. Again, if you have any questions, speak to your client. I'm going to say that a million times. It shows that you're not making assumptions. Never make assumptions. Everybody makes assumptions when it comes to disability stuff, and they're usually wrong. Allow your ensuring accommodations as part of effective advocacy. Don't take things for granted. Accommodations, physical, invisible, or psychological disabilities. This is the hardest one in my experience, because people really don't talk about or admit to any psychological or invisible disabilities. They like to keep it private, so they don't. It's important to communicate what's out there and why it's important to disclose and how to disclose an invisible disability. Now, when you're talking about most public accommodations, you're talking about places that would have accessible environments. And the ADA will satisfy the needs of most persons with physical disabilities, like accessible pathways, accessible parking doors, but there isn't really things that involve persons with invisible disabilities. And there are things like needs for additional breaks in court proceedings, to break, to stand, to stretch, bathroom breaks, clothing issues. I mean, these are all things that are accommodations that can be requested. Inability to leave your home. What happens if a person, because of a disability, cannot leave their home? These are accommodations. Inability to concentrate or exhaustion for proceedings going on for a long period of time. Cut proceedings to an hour at a time, 2 hours at a time for people with things like chronic fatigue syndrome. They have radiation appointments and they have to be at a doctor. They're tired. These are all accommodations. Use of a service animal. I just read a transcript for a criminal proceeding in which a judge said, no, you can't bring in the animal, it's too much of, it's too prejudicial. No. It's one of those things that I was shown the transcript, I was like, so when are you moving to recuse the judge? You need for plain language documents. If a person has an intellectual or developmental disability, they may not understand the documents that they're getting. They need to be explained the documents that they're getting. If a person is deaf and they are in a family proceeding, they're not going to admit to you that they don't understand the documents. And most people that are deaf and graduate from high school in Florida graduate with between a 3rd and 4th grade English ability, which includes those folks that go to FSDB, the Florida School for Deaf and Blind. They will not be able to understand legal documents. So to provide them a document and say, read it and understand it, whether it's a parenting agreement or otherwise, is impossible. You're setting them up for failure. Without providing the documents translated with an interpreter and to have the documents read or in plain language, it is not the accommodations they need. And those are disabilities where if you know the parent or you know the client and you know what they need and what they don't, these are things to ask for and acknowledge. So sometimes when you do have a parent or a child and they tell you, well, I'm deaf, if you know nothing about deafness, look it up. Look up what are the issues. And English is a huge issue when it comes to people that are deaf. Which leads us into sensory disabilities, blind or low vision. Whenever I have a blind client, I say, so what do you do to read documents? Do you have a screen reader? How do you prefer I send you the documents? Do you have any transportation needs? How can we help you in your transportation needs to be sure that that you get to your needs, that you can make your appointments on time? These are all factors to take into account. These are all accommodations.
question?
Yes.
All the transportation costs is more than a bus pass. It is a driver that's going to pick them up and take them to and fro.
To the extent that they need that in order as an accommodation. If there is a nexus between the disability and the need, then yes. For example, if you live in a community where where they don't have good public transportation, then you're not going to have good STS service, paratransit service. Or if the client is not or if the person never signed up for STS, because I have many times that you get a person like, what's paratransit? Never knew I could get a pass. So, yeah, it depends on what the person's needs are. That would be an accommodation. Deaf or hard of hearing, do you need an interpreter, a CDI? Does anybody know what a CDI is? A certified deaf interpreter? A CDI is a person that breaks down the language for a person that has minimal language facilities if they're deaf. So they work with the sign language interpreters to break down the language more, so folks that do not have a good understanding of sign language can understand. I've had clients that most parents of deaf children do not understand sign language. So when they grow up with these children have no language ability. They use things called home signs, which their parents and the children make up signs to communicate with each other. So in circumstances like that, you may even get a child that does not understand sign language. So you may get a sign language interpreter, and this sign language interpreter will say, nope, doesn't understand anything I'm saying, doesn't understand sign language. And then you have an issue where you have to break up language even more, and it's common with children that are deaf. So even if you get foster parents that know sign language, they may have a difficulty because the child has such a low language ability. And you'll also find that in places like South Florida, where you have a lot of people coming in from different languages, from different countries that are deaf and don't know American Sign Language, and sometimes don't even know their sign language from the country that they're from, because sign language is not universal. So, what questions do you have? Yes. Go for it. Perfect question. Love it. Perfect question. There's different ways to do it. Every courthouse, every circuit has an ADA coordinator. There's a rule which is Rules of Judicial Administration 2.540, and I know it well because I drafted it. Rule 2.540, Rules of Judicial Administration. Every courthouse is required to have an ADA interpreter. If you want to know who it is, you go to floridacourts.gov, and they have a whole listing of them under disability services. And they have and each of them is supposed to have an ADA policy. You call them up and you ask for, if there is something that the court needs to provide, you call them up and ask for it. They have to tell you before the hearing whether or not whether or not you're going to get your accommodation. If they deny it, they have to deny it in writing. So so it's really something that places the burden on the court to advise the person whether or not they're getting their accommodation. Those are accommodations that are actual physical accommodations that have nothing to do with procedure within the courthouse. So I tell people whenever they need an accommodation to be sure to contact the ADA coordinator. Why do I do it too? Because the ADA coordinator knows a lot more than the judge or the judicial assistant. So that's the perfect point person to go to. If they deny the accommodation, you have an appeal to the chief judge. So that's how you ensure that you have it in the courthouse, but you also have to make sure that you have it in the record. So for the record, if it's an interpreter, you could say, Judge, I went to the ADA coordinator and I requested an interpreter for the proceedings. If you don't have an adequate interpreter, you continue the hearing. You say, Judge, my client can't participate. My client speaks Creole ASL, French ASL. This person doesn't do it. And what you're going to need sometimes, if you have French ASL, you may need video remote interpreting. They have video remote interpreting in jails now, and they should be able to have it, and you could probably get it on your laptop to the extent that they have a decent connection in the courtroom. The issue with the CDI is the CDI is going to know how to translate it into more basic ASL terms or more basic sign language terms, but they may not know the specialized language. And depending upon the specialized language that you need, a CDI may not help because your client may understand French Sign Language really well. So an accommodation like that would be a video remote interpreter, bring your laptop, have a good connection, and have them able to have an interpreter online. So these are all issues that should be done. How do you communicate involving policies and procedures? I need an extension of the permanency plan. Let's say that's one of the things. You bring it to the judge and you say, Judge, my client has a disability. They need additional the parents need additional parenting classes. They have an intellectual disability. And we need an extension because of their disability. You put it on the record. The judge writes it in his order. You make a motion for it. When you're dealing with people with autism, what I deal with all the time, especially in evictions things, when parents or somebody has a meltdown, what do you do when somebody has a meltdown? How do you make a more sensory-friendly environment? What are additional things that you need to do? With regards to things like that, sometimes you're going to need to get a doctor's letter saying, Mr. Smith has autism, Mr. Smith is deathly afraid to go in the courthouse and will freeze up and will not be able to communicate, even though he's verbal in a normal way, because when in the courthouse he will be entirely not verbal. It does not reflect his intelligence. And you may have to have the doctor testify to that and say, as an accommodation, what we need is we need to be available remotely. We need to do it in a different room. We need to do it in a different courtroom, in a different courthouse.
And to that end, I don't think I generally have too many problems with our court, takes that very seriously and trying to make as many accommodations as possible and requesting time. The general concern I have with the providers that our parents are put with,
Mm-hmm.
I get very frustrated and then bow out and say, this person's getting it, get it, and I don't, in my pushing forward regarding the providers having not provided the proper accommodation.
Okay. What you should do if it's the providers, any providers, is every one of the CBCs should also have an ADA coordinator. The goal is to find out who is the person responsible for this. Since they are recipients of federal financial assistance, they're required under Section 504 of the Rehabilitation Act to have a point person, an ADA coordinator. The ADA coordinator should be the person to request it from and do it in writing, and if you don't get it, then you go to the judge and say, I made this request, it was denied, they couldn't do this. The reason why I always focus on the latter and the coordinator is the law says, when I usually have a case as a civil lawyer for violation of 504, in order to get damages, you have to prove deliberate indifference. Deliberate indifference is when an entity has knowledge of what the law is and acts against what their knowledge is. So the only way to put them on adequate notice is to have somebody who is a decision maker in that chain to deny the accommodation. So if you go to a person, a case manager, and you say, I need something, and they deny it, and you don't go to the ADA coordinator, they're going to say the case manager really didn't have authority to grant it or to deny it. So they automatically said no. So you always have to speak to somebody that has the authority. So you always have to look for the ADA coordinator. And also if you receive federal financial assistance under Section 50, under anything, if you receive federal financial assistance under anything, you have to comply with Section 504. Section 504 also requires a grievance policy. So you're going to have, if you can't get it through, once you go through the, once you request it from the service provider and you can't get it, and you say, we're going to go to their other folks, then you go to the court too. And you get an order from the court, just like in the two orders that you saw. The court is going to say, we're going to order them to provide the service using a sign language interpreter. Because if they don't, the court's liable. It's whenever the court contracts or requires or orders a program in service, that program in service becomes a program in service of the court. So if a court says you must do parenting classes and you must go to XYZ parenting classes, it's a court service. You can also go to the coordinator, the under 2.54 row, and make that complaint too, and then you're going to get the court on their back. But you must complain. You must advocate, because sometimes you don't need to advocate to invoke the law, but you do need to advocate to be successful. And you do need to be the squeaky wheel. And also, it's going to depend on the TPR, because if you document your record adequately, then the ADA issues are preserved. And this is what we spoke about before. If you don't advocate, it's not going to be in the record. And they could lose their children, then later say, you know what, it was because I was autistic, it was because I was deaf, they took my child. No, we asked for everything. So there it wouldn't happen. So what are your 10 other questions? So if you have any other questions, you can always call me or email me. I'm more than happy. This is like a Jeopardy thing. What type of accommodation do you need? You ask me, I'll be able to tell you. Are there any other questions? Yes.
I've got an intellectually disabled parent and a TPR I was just appointed to. But are they entitled to a mental health with someone with a low IQ? She's interested because she's got all the supports that was ordered under the baseline. It's going to be, so they'll do a motion for reunification with the other terms. Suspended. But anyway, it's a good case, but are they entitled to a mental health advocate as well? It's worth pointing around, or some circuits do it, have them have an additional aid. What do you know about that? Mental contact disability rights. Florida, and I've heard what the circuit court judges tell an intellectually disabled parent, you are entitled to, in addition to your
Ooh, that's a really good question because that just came up in one of my cases too.
And I don't want to use her APD caseworker because she's going to be my great witness.
Right.
Talk about all the support she's got.
And well, you could, if you get no opposition, you ask for a judge to appoint a guardian ad litem or an attorney ad litem or or a mental health advocate to assist her. If your judge is, if the other attorney is not advocating, ask.
Well, they just don't want to fund it, you know, they don't really oppose it, they just don't want to fund it. But I don't know, I've tried to research the law and I can't find anything, but I'm told to go to disability rights.
Okay.
They have a list of providers.
Yeah, absolutely. There's a list of providers if you want to try to get them to fund it. The question is, what is it an accommodation for? What is the nexus? So if you say this is an accommodation in order to start her out, it's essentially like a case manager instead of a mental health advocate, and you need a case manager in order to get her started. So it's an additional service more than it is an advocate. So if you put it out as an additional service the person needs because of their disability in order for them to access the programs and services that are available, yeah. It's like any other caseworker, therapist, service provider out there, and that's how you do it. You don't do it as something that is something that nobody else has, but something that she needs in order to access the services that the court has already provided, or that the CBC has already provided, or that whomever else has already provided it in that circumstance. But the way you word it is there must be a nexus between the disability and the need. If there's no nexus between the disability and the need, then it's not going to work. How are we doing with time? I'm over my time. Please, if anybody has any questions, email me. I have business cards if you want business cards. I'm on the app if you want more information on me, and I put my picture there too if you need to make sure that I'm me. And thank you so much.